Hey everybody, welcome. I've been wanting to do this video for a while because I'm really into artists' rights to use intellectual property, and the laws are always changing. Facebook just changed their privacy policy, their image use policy, all that kind of stuff. Um, Meta did really. And I thought that was really kind of like bold and daring that now they're saying, like, well, if you put your stuff on here, we can use it, to my understanding. Kind of like TikTok does, But anyway, so I've been waiting for somebody to cover this story and nobody has yet. So I'm going to do it. So here we go. As you may or may not know, Eminem, well, really 8 Mile Style LLC is suing Meta because Meta has used Eminem's songs without his permission. So here we go. We are going to read the document, and so yeah, I've got it pulled up here, and I'm just going to share my screen. Just one moment. Here we go. Let's see if it will let me share screen. If not, I'll just read it to you guys. So here we go. I'm going to click it, and I think it's going to work. Anyway, yeah, we shall see how it works. Picture in picture. I think it's working. All right, well, if it's not, anyway, I've got the document pulled up, so here we go. So they are filing this in Michigan, which makes sense, because if you know Marshall Mathers, that's where he's from. 8 Mile Style, I think, owns his music publishing, which is pretty good. You want to own the rights to your own, creation. So here we go. They are versus Meta, which includes Facebook, Instagram, WhatsApp, and I'm sure more, behind the scenes. But anyway, they want a jury, it looks like to me. I'm not a lawyer. This is not legal advice, by the way, and that's in the description. But I just wanted to see what's going on here. So this document's 32 pages. I'm going to skim it a little, just so we can get an idea of the details. So here we go. Plaintiffs, 8 Mile Style, and Martin Affiliated LLC. So together, 8 Mile Style, I guess he has two LLCs to manage his business. So they bring this action for willful copyright infringement and related claims against defendants Meta Platforms, Inc., Facebook, Instagram, WhatsApp. And I think you'll be shocked, by the way, when we get to how much money they're asking for. So here we go. As follows. Introduction. Okay, so this is an action by 8 Mile Style. They own 243 musical compositions listed in Exhibit A, which we will get to because I want to know what songs they're talking about. Some of which are the most iconic songs of this generation, recorded by world-famous artist Marshall Mathers, aka Eminem. I think that's fair to say in most rooms. He's definitely iconic. I love the way they wrote this. The lawyers really went all out. I'm excited. Okay. Coke Zero, fueled by Coke Zero. All right, no sponsor. And don't drink it because, it's not good for you, but in my opinion. Anyway, unauthorized storage, reproduction, and exploitation. So people are creating reels and they're creating shorts or content or videos or whatever it is you do on Facebook, right? Instagram reels. And Eminem's not getting paid for the use of his music. I think that's basically what they're saying here, but we're going to get to that. Defendants, Meta, had no license to store, reproduce, or distribute the infringed works, but have nonetheless created and stored copies of the infringed works on their servers. I think that's going to be key. Have encouraged their use and distribution, those copies, to their billions of users. Yeah, you know how they do suggested songs when you're creating content? I think that's what they're referring to when they say encourage the use. Stored on the servers is really interesting because it's well, who owns the song? You don't get to have a copy without agreeing to the way it should be used. You know what I mean? But we'll see what's decided. the general global public, yeah, that's fair to say with Facebook, via their availability in the music libraries of Meta's global online services, Facebook, Instagram, and WhatsApp. Yeah, even WhatsApp now has like status updates and stuff. On information and belief, despite there not being licensed, so there's no agreement for them to use it. I think they're going to argue that their new policy makes it so they don't need the permission, but we'll see. The recordings of the 8 Mile compositions have been reproduced and synchronized with visual content on Meta's platforms across millions of videos, which have been viewed billions with a B, billions of times. Wow. Meta has also created online tools within their services, such as Original Audio and Reels Remix, which allows and encourages its users to steal 8 Mile Styles music from another person's post. Yeah, exactly. So even if like Eminem has one song registered with Facebook, if like somebody else creates a video and they're using a copy of that, he might not be getting the credit for that. You know how that works, where you can just use the audio. Anyway, yeah, resulting in exponential infringement. I'm sure it's totally hard to keep track of like all of the people who use it after a while, because it's like copies and copies of the same song, copies. They're all titled different things. They might not even be titled the name of the song anymore. Anyway, the rampant of which Meta is guilty is not a case of merely allowing its users to infringe the 8 Mile compositions by means of its users uploading the compositions, etc. Rather, this case involves Meta's knowing infringement of 8 Mile compositions by first reproducing and storing them in Meta's online music libraries and then distributing them for users to select and incorporate or synchronize into their own content. So it's interesting. That's very interesting, because now I'm starting to understand. So they're saying Meta has their own copies of these songs, I think is what they're saying. Like Meta has downloaded or copied or whatever Eminem songs, and they're offering it from their own vault for people to use, instead of like, oh, I'm on my friend's account, I'm like, watching her video, oh, she is a cute song, I'm just gonna use their same audio for my reel. No, they're saying Facebook and Instagram are saying, no, use this. So it's not coming from your friends, it's coming from Meta. That's interesting. I didn't know they did that. I thought any music they were offering was under the agreement of the publishing company, but I'm wrong. Maybe, perhaps, if this is true. I wasn't there. I don't know. But anyway, yeah, that's interesting. Okay, so thus, as Meta knows, it does not enjoy and is not eligible for the Digital Millennium Copyright Act's DMCA safe harbor positions. Okay. Indeed, Meta's knowledge that it needed a license to reproduce and distribute the 8 Mile compositions is demonstrated by the license Meta entered into with Audium, now owned by Barry Fox Agency, in 2020. So this is even before they changed the policy, I think, if I'm not mistaken. Okay, although Audium did not have the authority to enter into any license on behalf of 8 Mile, Meta tried to negotiate unsuccessfully an 8 Mile style license as part of the first Audium license. Meta knew that no license was granted by Audium or 8 Mile style as part of those negotiations. If I say 8 Mile instead of 8 Mile style, you know what I'm referring to. Okay, the LLC, not the movie, or, okay. The Audium license with Meta contained no reference to the 8 Mile style compositions. Although on information and belief, the license with Audium did not contain references to other companies' artists' musical compositions or private licensed. The subsequent Audium Meta license likewise did not have any reference to 8 Mile style, and Audium also had no authority to negotiate or enter into a license with Meta as part of that transaction. Interesting. Indeed, these facts were confirmed by Audium prior to this litigation, and Meta has not provided 8 Mile style with any license authorizing its use of the 8 Mile compositions. I mean, some artists are under like, Universal or Sony or whatever. And if you have an agreement with Sony, you can use all those artists' songs, more or less, right? But 8 Mile owns Eminem's songs like a little silo, it seems like. So I don't know if Meta knowingly did this, if they just thought it was part of the whole thing. I am going to quickly look up Audium because I don't hear that a lot. Oh, they're a digital music royalty collection company built on proprietary collection of royalties. Okay. Now I'm going to say Audium Eminem and see what we get in Google here. Dun, dun, dun. Okay, so it's just very interesting. I don't know what Eminem's relationship with Audium is, but it seems like Meta is going to argue that Audium granted them the use of this content, and Eminem is saying like, or 8 Mile is saying like, no, Audium had no authority to do that because Audium is a digital royalty collection and payment engine. Okay. All right. Okay. So Audium was licensing this to Meta, but 8 Mile Style is saying like they had no right to do so. And I guess it's really Meta's problem because it's like on their website. You know what I mean? Anyway, let's go back to this. So here we are. We're at number 8 in this document. We're on page 4. I'll provide a link in the description or like a pinned comment or something if you want to read this yourself. Anyway, okay, so nonetheless, Meta has reaped the financial benefits of having the 8 Mile compositions available to its users as part of their online services. Yeah, because like, where's the Eminem music? And I'm saying you've got to have it. Meta executives have actively encouraged such rampant, they love that word, that's so interesting, rampant infringement in order to attract as many users as possible, of course, among other things, making advertising on their services more profitable for themselves while advertising accounting for, with advertising accounting for 97.8% of Meta's total revenue. Wow. As of 2023, that's wild. I guess that makes sense. Let's look up rampant since they keep using it. I mean, lawyers don't just use a word for no reason. So let's see what this means. Rampant, definition from Oxford, spreading unchecked. Okay, rampant. Yeah, it is spreading. It's unchecked. Okay, got it. Okay, here we go. Go back to the document now. All right, rampant infringement, 98% almost of Meta's revenue in 2023 was advertising. Yeah, so they're saying maybe he even used his songs in the advertising. I don't know. I wonder if they have a library of, video evidence of this. I would be interested to see it. All right. So they're saying a portion of Meta's profits are attributable to this infringement. They want their cut, right? 8 Mile's like, hello, pay us, right, for what you're using. Recognizing it does not have a license and that it is liable for willful knowing copyright infringement, allegedly, after 8 Mile Style brought this matter to Meta's attention. Meta has removed several of the compositions from its music libraries in the preceding months, including Lose Yourself, In the Music, The Moment You Own It, You Better Never Let It Go. However, a karaoke version of a karaoke version of Lose Yourself in the style of Eminem, that was the title of this other, file, a piano instrumental cover titled Lose Yourself Piano Version. Okay, so there's little exceptions to what they removed. All right. And one regular cover version by artist U-Rock, who sounds familiar, I don't know why, all remain available as of the date of this complaint, which was June of this year, 2025. Okay, so they removed some of it, not all of it, when 8 Mile complained to Meta. Okay, interesting. This in addition to other prominent Eminem works, which remain available on Meta's services, such as Till I Collapse. Okay, Meta's years-long, we're on number 10, years-long and ongoing, ongoing years-long infringement. Yeah, that's interesting. So they're like, this is not a one-time thing. This is not one video. This is like a habitual using our stuff without paying us. That's what they're arguing. 8 Mile competition. Okay, it's another case of $1 trillion. And they even wrote this with a T, dollar company. Okay, so Meta's years-long and ongoing infringement of the 8 Mile compositions is another case. What are the other cases? Interesting. Another case of a trillion with a T dollar company. Wow, they're not playing around. They're like, listen, you guys made, a lot of money on this. You have a lot of money. Like, don't be greedy. Come on now, pay us. Exploiting the creative efforts of musical artists for the obscene monetary benefit. Yes, obscene. Yes. Of its executives and shareholders without a license. What happens if you get pulled over without a license? I'm just saying. And without regard to the rights of the owners of the intellectual property. This is the crux of it for me. Number 10, 1,000%. I mean, I know there's AI, whatever. If they're going to own the AI art, fine. But if an artist makes their own art, they're entitled to their intellectual property. That's just a non-negotiable, in my opinion. The 8 Mile compositions are some of the most valuable in the world. Okay, girl. And 8 Mile Style is very protective of these iconic songs, fairly so. Defendants have enjoyed massive profits at 8 Mile Style's expense in an amount to be determined by copying and making the 8 Mile compositions available to Meta's billions of active daily users. Daily users, right? Billions of people a day, right? Okay. Think of the ad revenue. Wow. Trillions. Okay. 8 Mile Style. I mean, let's just say $1 trillion. If 98% of that is ads and some of those ads have Eminem songs in them, you do the math, honey. It's pretty close to $1 trillion, right? We're talking about hundreds of billions of dollars a year. All right. We're on number 12. 8 Mile Style seeks monetary damages, of course, including actual damages for the diminished value of the copyrights by defendants' theft of them, lost profits, and defendants' profits attributable, to the infringement or alternative maximum. Wow, these are a lot. It's a lot going on. I'm just like wrapping my head around it. Okay, so they want their own lost profits from licensing music. They want a cut of whatever Meta made by using the music. This is my understanding. And they're also saying the fact that you used our stuff without our license to you decreased the value, because now other people feel like maybe this, I'm inferring, other people are like, oh, well, maybe we could just use it. We don't even need their permission. You know what I mean? Anyway, there is a number here. So lost profits, yep, diminished value, profits attributable to the infringement, or alternatively, maximum statutory damages for willful copyright infringement for each of the works. $150,000 per work. Are you ready? Sit down if you're not. Per work, $150,000. They want this times 243 works, times 3 platforms. Oh, girl, let's do the math. Oh my God, my ex probably could do this in his head, but I'm about to use a calculator. Here we go. $150,000. Sounds pretty good. Times 243 works, which we will read in Exhibit A. I can't wait. Times 3 platforms, Instagram, WhatsApp, and Facebook. Wow. We are talking about $109 million, $350,000. Oh my God. If they win this, bro. Ooh. And you know what's crazy is that won't even hurt the pockets of Meta at the end of the day. Even though it's a lot of money, like they'll survive if they lose, you know what I mean? But I can't wait to see what they end up with, like who wins this, because it's going to set a precedent one way or another. With my $2 soda. Anyway, okay. So they're asking for about $100 million and probably them to stop using it unlicensed. But anyway, all right. And all other remedies available under the Copyright Act for Meta's willful, direct, and/or secondary infringement of 8 Mile Style. Let me say it right. 8 Mile Style's compositions by reproduction, storage, distribution, and transmission of the compositions. Further, tell me, 8 Mile Style requests a permanent injunction. Yes, that's more valuable than the money to me, I think, personally. But to stop Meta's ongoing infringement, as well as costs and reasonable attorney's fees and prejudgment and post-judgment interest. Ooh, who saw that coming? Calculated according to law. So they're like, this is what we want, and you can give us all the sprinkles on top too, sweetie. Thank you. All right, so the parties we know, 8 Mile Style LLC is a Michigan LLC, limited liability company, honey, with its principal place of business being at, I'm not even going to read it, but there is an address here. We should send them a little good luck card. I don't know them, obviously. Anyway, although I did see Eminem once in Manhattan. Anyway, let's go on. He probably wouldn't remember that story. Okay, 8 Mile Style co-owns and administers the musical compositions identified in Exhibit A. What do you think? Should we just skip ahead to Exhibit A? I kind of want to, but we'll wait. It also, okay, now they're going to explain to us. All right, so if you remember at the top of this document, it was telling us it's 8 Mile Style LLC and Martin Affiliated LLC. Both of them are a team versus Meta. So now let's learn what let's learn what Martin Affiliated is, because I've never heard of that. It says it's an LLC in Michigan as well. Oh, and they have the same address listed as 8 Mile Style. So they also co-own and exclusively administer these compositions. I wonder if like some own part of the catalog and some own another part, or if they were just started at different times and they co-manage it. I don't really know. I'm sure we can look into Eminem's team history representation and figure that out. But anyway, here we are. The defendants, let's look it up now. So we've got Martin Affiliated LLC, publisher. Yeah, so they are his publisher. They're Eminem's publisher. And 8 Mile Style sounds more like his own brand, in my opinion, but they do have the same address. Oh, wow, this is interesting. Huh. Wait, let me open this. Let me open this court document. I'm just reading because I looked that up and I found out they also sued Spotify last year. Summary judgment. Filed a response. Spotify. Oh, I didn't know that. Let's look up what the outcome of that was. Spotify. Yeah, I don't know. I think he might even own both of them, or maybe his management owns one or what. But okay, so last year, 8 Mile Style alleged that Spotify streamed their music without proper licensing. Okay, so they're tying up loose ends here. They're going through their whole catalog recently. They're trying to figure out, where is this money going? Who is not paying us? Last year, the judge ruled that while Spotify didn't have a valid license, they were protected by the doctrine of equitable estoppel, meaning 8 Mile Style waited too long to address the licensing issues and therefore couldn't claim damages. Interesting. So they won that. They filed that back in 2019, and the decision, I think that's what Rolling Stone is saying here. Yeah. Interesting. Maybe during COVID, Eminem was like, hey, I got some time. Let me get all this stuff off my to-do list. You know what I mean? I mean, at the end of the day, I don't know if that's valid. I'm not a lawyer, but like, people are always playing his music. They're always going to be playing his music, in the near future. So I don't know that necessarily makes any sense, but that's not what we're dealing with here. We're talking about the Meta one. So here, let's get back to business. Meta is licensed in Delaware. You might be interested to know. I'm back to reading number 15 here. I'm on page 7. Delaware Corporation, that's like a tax haven. Anyway, it's a corporation. It's not an LLC. And their principal place of business is actually in California. They are registered in Delaware, which is super interesting. Okay, anyway. Yeah. Let's learn something. So Meta Platforms registered in Delaware. And then there's also an LLC for Instagram under that umbrella and a WhatsApp LLC. And those are also registered in Delaware with a California address. Okay. All right. So this court, we're in jurisdiction and venue now. So they filed it in Michigan, probably because they're like, we're here. We don't want to go all the way to Delaware or wherever, California. So anyway, 18. This court has federal question jurisdiction over 8 Mile Styles copyright infringement claims. All right. The court has general and or specific personal jurisdiction over the defendants because they're from Michigan. That makes sense. I'm not a lawyer. This is not legal advice. Defendants have continuous and systematic contacts within the Eastern District of Michigan such that they can be found to be essentially at home within this district. Exactly. That's what we just said. 21, Meta has also acquiesced, such a pirate term to me, like Pirates of the Caribbean, acquiesce to this court's jurisdiction over it in prior. Okay, so Meta's like, fine, we'll do this in Michigan. In prior litigations, including in one involving the same parties. Oh, so they've already sued Meta before. Wow. They used his song in a Meta ad campaign promoting its new application, Facebook Home, in 8 Mile Style LLC versus Facebook Inc. This has got to be years ago because now Meta owns Facebook. But when Meta stood alone, interesting, when Facebook stood alone, Meta did not move to dismiss for lack of personal jurisdiction during the nearly year-long pendency of the case before it was jointly stipulated dismissed by the parties. So maybe they settled that one out of court. Maybe they'll settle this too. This might not even go to a jury. Especially when we're talking about so much money, talking about $100 million, a little more than that. Maybe Facebook will offer him, I don't know, even 75% of them would save them like $25 million. All right. Okay. Oh, upon information and belief, Meta maintains a strong presence in Michigan, including a Detroit office. So they both have a home in Michigan. Where else did they have offices? Wow, I didn't know that. Upon information and belief, Facebook alone had 5,350,100 users in Michigan in 2011, which accounted for over 50% of the state's entire population. So now they're explaining, like, look, we're filing this in Michigan. It's a global case. However, like, it's a global audience in Facebook. But even here in Michigan, 1 out of 2 people has probably seen these songs. Like, they're using Facebook, you know? I mean, the other half is probably like babies and old people. Like, everybody has Facebook now. Facebook had 176 million users in the United States in 2011. I wonder why they're using such old data, in my opinion, but I don't know. Currently has an estimated 253.5 million users in the United States as of 2025. That's more than, isn't that like more than half the population of the US? Let's see. I thought we were at like and a half, so almost 254 million users in the United States. That's more than half of the United States has Facebook. Wow, it's crazy. Or at least there's that many users. Maybe people have more than one account. It's hard to say, you know, but a lot of people. So a lot of people have access to the music. They're using the music. You know, they're not paying Eminem for the music. Facebook estimates that it improperly shared at least 414, almost 2.5 million Michigan citizens' private personal information with intelligence gathering and consulting. I don't really think that's directly relevant, but they're kind of coloring Facebook as like maybe not having it all the way together. They're like, look, they leaked 2.5 million Michigan citizens' personal private info. Dude, I wonder how much. Oh my God, that's crazy. If 1 in 2 people in Michigan use Facebook, they leaked. How many people live in Michigan? This is what I do. See, this is why I'm so interested, because I learn a lot by reading one document. There's 10 million people, a little over 10 million people in Michigan. So Facebook has leaked almost a quarter of their info. I wonder if they've leaked a quarter of the whole US. That's scary. Let's not even, allegedly. Okay, upon information and belief, defendants regularly solicit and transact business in Michigan by continuously and systematically targeting consumers, not customers, viewers, users within the state. They have to show that this is relevant in Michigan because that's where they're filing the case. So that's why they're giving us all this Michigan Facebook data, metadata. Metadata, get it? Anyway. I could never work there. I would make that pun every day. Okay, anyway. So in operating its websites and applications, Meta specifically tailors and recommends ads, content, and music, including the infringed works, based on users' geographic location in Michigan, and allows users to target geographic areas in Michigan for promotion of the user's own paid sponsored content. It is kind of relevant because Eminem's from Michigan. 8 Mile was shot in Michigan. They're directly advertising to people in Michigan. They're probably using his music. I don't live there. I don't know. But this might even be more relevant than anywhere else in Michigan because they're, when you geographically target somebody with an ad, you're going to want to give them content that's appealing directly to them and their interests. And if you live in Michigan, maybe you take pride in the fact that Eminem is from there, and you would probably respond better to content that has his music in it because you're like, oh, Michigan vibes, you know what I'm saying? So maybe this is actually a really good point to make, and it's not just saying this is why we filed in Michigan. It's also a lot of this happens in Michigan when they're not paying us. It's probably views from Michigan, or a lot of views from Michigan. Anyway, defendants, Meta, have committed tortious acts. What is tortious? That's interesting. I've never heard that word before. Oxford said it means wrongful. You gotta love lawyers, man. They know a lot of esoteric words. All right, so they've committed wrongful acts of copyright infringement within the state of Michigan, described herein, which caused foreseeable injuries to 8 Mile Style injuries, which was organized under the laws of Michigan and located, they have a lot of footnotes, in Michigan. And again, we're back to they've been reproduced, saved, distributed, synced by Meta's users throughout the state of Michigan. Okay, so that makes sense. And that's the jurisdiction of this court is within Michigan. So great. That makes a lot of sense. Meta previously admitted in its answer in the 2013 case between the parties, back when Facebook was its own Inc. before. Now it's it's just part of Meta, I think, tax-wise, structure-wise. All right, so Meta admitted in 2013 between the parties that it maintained a registered agent for service of process within the state of Michigan. So that's relevant. That's why we're serving it here. Additionally, upon information and belief, Meta has partnered with the University of Michigan to create a social media data archive. Interesting. And to provide comprehensive access to the full public content archive from Facebook and Instagram, including providing $1.3 million in funds to do so. That's chump change for them. Venue is proper in this district. Okay, yes, we know. Michigan's the right place to file it. That's what they're saying. Now we're at the ads. We're on page 10. Number 30, 8 Mile Style is an independent music publisher and copyright admin that owns and administers some of the most iconic and successful musical compositions in the world by recording artist Eminem. 8 Mile Style owns and exclusively administers the 8 Mile Style compositions, all of which have been registered with the United States Copyright Office. If they can't resolve this, it'll go to a federal level, I think, but they might just settle. Defendants do not have a license to display, Yes, we've established that. To that end, on March 17th, 2020, Zaina Grenier, I think I'm saying that right, head of North America Music Publishing at Facebook, it sounds like a great job, stated in an email to Audium representative that Facebook was aware that Audium was interested in a direct licensing relationship with Facebook for the catalogs it represents, and to send Facebook a list of catalogs represented by Audium. Oh, now it's getting juicy. So that they asked for that in March 2020. March 30th, end of March 2020, Audium wrote back to Facebook, I agree based on our conversation that the next step for Audium is to give you a client list so you can identify which repertoire might have already been licensed to Facebook by the clients directly. Okay, so Audium represents a bunch of clients as a digital music publisher. However, some of those artists might already have an agreement with Facebook through their record label or their own team or, stuff like that. So they can't relicense that stuff. It's already, anyway. Okay, so then May 1st, which is 2 months later, Audium wrote back to Facebook and said, here's the list. It'll include a full list of publisher names that we represent. Tell us which ones you want. So later the same day, he sent the list of clients over. It says this list did not include, how did they get this email? Wow. This list did not include 8 Mile Style nor Martin Affiliated. Audium also sent a list highlighting the most lucrative Audium clients on May 7, 2020, of which 8 Mile Style and the global hits of Eminem would have been included had they been Audium clients, which they were not. And again, 8 Mile Style and Martin Affiliated were absent from the list. Now they're establishing the fact that Facebook knew Audium did not represent Eminem, and yet they're claiming, oh, we thought he was on the list. And 8 Mile saying no, you knew he wasn't on the list. Okay, honey, you had the list. Okay. I bet Audium gave him the list, if I was going to guess, because they were like, don't get us involved. We told them, we don't know you guys like that. You know what I mean? All right. So about a month later, on June 9th, 2020, Grenier asked, this is the best tea, by the way. Grenier asked Audium about a HFA market share for the clients represented by Audium per the list sent on May 1st, 2020, as well as for further information regarding 8 Mile Style. What? Why? I don't know why they're asking about 8 Mile Style if they weren't on that list. That's very interesting. However, on the same day, Parnes responded only regarding HFA market share questions for clients at Audium. And so Audium wrote back and they were like, oh, here's your answer about the market share. And then Facebook wrote back talking about the market share, but nobody ever addressed the talk about Eminem songs. Okay. So they never really resolved that. And then May 23rd, 2025, now we're 5 years later, we're in this year, May, Audium has confirmed a letter from so-and-so, the vice president of business and legal affairs, that under Audium's licensing agreement with Meta, called the Meta Audium Agreement, all right, Audium did not claim to represent 8 Mile Style and or Martin Affiliated. They said, don't sue us, sue Meta. Smith also confirmed that after the first Meta Audium agreement was signed, Audium delivered to Meta information for compositions, and they did not include 8 Mile Style compositions. Yeah, we know that part. I love that they repeat things 85 times in these documents. But anyway, they entered into a license agreement, Audium and Meta. It was for 2 years, 2-year-long agreement. And Audium confirms that 8 Mile Style was not included in that license agreement. Right. The agreement started in late 2022 or early 23. They're not sure. Okay. Meta was aware of So they knew 8 Mile Style was not on that list of Audium clients because he was or he wasn't on the list. You know what I'm saying? And they're saying he was not. All right. So for that reason, 8 Mile Style needed to be contacted regarding the licensure, as 8 Mile Style stated in its previous 2013 complaint against Meta for infringement on Eminem's intellectual property. Ooh, here's a fun quote. Quote, plaintiffs, that's basically Eminem, but it's 8 Mile Style and Martin Affiliated. Plaintiffs are extremely selective and deliberate in the licensing of Eminem compositions, and given his immense popularity, they talk about our prices are high, honey. Plaintiffs command significant payment for licensing of Eminem compositions. So they told him back in 2013, they said, listen, Meta, you got to come through us. We own our own shit. We own our own stuff. This is not, this ain't your average artist. not a lot of artists own their own stuff still to this day. And it should be more common because of things like this, where like you want to get paid what you're worth, you know? Meta has instead rampantly infringed. So they used the songs anyway, allegedly, stored the copies, distributed, allowed and encouraged its billions of users to sync these distributed reproduction copies. So those covers, the piano cover, the U-Rock cover, and that third one, allowing users to create and sync unauthorized and unattributed bootlegs. Ooh, bootlegs. Yeah, they pretty much are bootlegs. Yeah, under the guise and attribution of a user's own original audio. Yeah, so Meta is saying, well, it was our users that created the audio. It wasn't us. And Eminem's like, yeah, but my song is in that audio. Like, you need to pay me for it. Allowing users to even download and save audio copies, to create personal music libraries and use in the future. So people are getting his song for free. They don't even have to buy it. They don't even have to listen to it on Spotify. They don't have to listen to it on iTunes. They could just listen to it on Meta products. And he's not getting the pay for those plays, you know? Like if you listen on Spotify or iTunes, he gets paid every time you play a song, you know? And then Meta has to get these licenses so the artists get paid. Because it's intellectual property. I'm not a lawyer. This is my opinion. All right, here we go. For years, each day, they've done this. The Meta created music libraries, which are available on Facebook, Instagram, and WhatsApp. All right, and it recommends in the For You page. We know about that. WhatsApp stories. Okay, I'm just skimming at this point because I think we have a pretty good idea. Reels remixes, original audio. The net result is the booming material financial benefit for Meta without paying any of the proceeds to 8 Mile Style. They're saying further, Meta's actions do not qualify for the narrowly construed DMCA safe harbor protection, which is intended to protect innocent digital service providers. Safe harbor cannot immunize a service for material stored there. All right, okay, here we go. A service provider must play no role in making the infringement material available on its site. So if you're like passive and this happens, like you're covered under DMCA, but if you know it's happening and you're complicit in storing, reproducing, distributing, then you owe somebody some money. That's what they're saying. Okay, all right. It's more of the same, so much writing. Meta's infringement is willful, knowing, and intentional, does violence to 8 Mile Style, and so on and so forth. Liable for contributory copyright infringement. All right. I just want to get to Exhibit A at this point. So if you want to read the rest of this, you can. We've basically covered it all. Now we're on the demand for a jury trial. You know, if you love Eminem or if you know who he is, I think a jury would probably rule in his favor. Oh, wow. Yeah. Look at all these titles. Let's see if there's, I know a bunch of them. 8 Mile, Till I Collapse, another PSA, American Psycho, Ass Like That, Bad Influence, Bad Meets Evil. This is like his whole library, literally. Like, and they found all these songs on there. They even have a percent grade of what controlled share Eminem owns in all these songs. Some of them are 100%, some are 25, 50, 60, depends on if, he collaborated with somebody on the songs. Oh my gosh, wow, this is a lot of songs. This is 3, 4, 5, 6 pages of songs, all included as of April of this year. Wow. I feel like, having read this now, I would say that it sounds like he's entitled to some money. I don't really know. I'm not a lawyer. This is all an opinion. This is not legal advice, but I hope we all learned something. Comment below. Let me know, like what you guys think. All right. Maybe more later, maybe not. I don't know. Facts are not defamation. Neither are opinions, honey. Bye.